That's good. So you're in what's called a box. After you pledge your equity interests in the real estate, essentially, you're placed on the debt side where you're really over leveraged, and they've taken your equity interests. Now they have you from both ends. But I'm going to tell you how to get out of it.
How do you deal with a mezzanine loan UCC sale, and what are the best ways of dealing with that?
Okay. So UCC sales are not sales of real estate. It is sales of personal property. Now everyone gets confused. They're like, Leo, I have a UCC sale. Oh my God, I've pledged my interest. I gave everything away.
For those of you that don't understand, when you hear a mezzanine loan is a pledge of the equity interest in the entity that owns the real estate that you gave a mortgage to. That is secured by a UCC security interest, and that's what Leo's talking about. So some of you may not have understood that.
That's good. So you're in what's called a box. After you pledge your equity interests in the real estate, essentially, you're placed on the debt side where you're really over leveraged, and they've taken your equity interests. Now they have you from both ends.
But tell them how quickly they can get the equity interest versus how quickly they can foreclose.
You can foreclose very, very quickly in a UCC sale, but I'm going to tell you how to get out of it. The power of how you get out of it, again, comes back to how you interpret your lender. You have to have a discussion with your lender. If you hear your lawyer, please don't hire a transaction lawyer who drafted the documents for you. They do not know how to traverse that terrain. I don't care if you have Skadden Arps, Wells Gosho, or the guy in Brooklyn or in New Jersey. Those individuals are not cut out to negotiate your loans. Not at this moment in time. You go to a competent law firm, and they will test the temperament of the lender in a UCC sale. Oftentimes, the lender will say, I am not listening to you. I am going to move forward with my sale. And I'll always mention what Jacob Fryman always says, Leo, make sure the client has, what should we make sure the client has? An appraisal of those equity interests.
The date of sale,
And
not the date after.
that's correct.
That's a date of sale. And the reason for that, we practice primarily in the Northeast, and this is true in all the Northeast states and in most of the states, but not everybody has the same UCC or foreclosure laws. But the way it works is, everyone talks about deficiency judgments, right? You give a personal guarantee. You have a $50 million asset. You have a $30 million loan. It goes to foreclosure. The only person that shows up is the bank, and they bid $100,000, and they get the asset. And then they come and send you a letter. You owe us a deficiency of $29,900,000.
Plus, you have to finish the building.
So if you have, the UCC says, and the foreclosure laws in most states say, that if the value of the asset on the date of the sale, either the UCC interest or of the foreclosure or the mortgage, is at or greater to the amount of the debt, irrespective of what it's sold for. Doesn't matter that the lender paid $100,000. There is no deficiency. And in most states, you must bring a deficiency action, if at all, within 90 days of the foreclosure.
Now, think of a borrower. I'll mention a very big one, Charles Cohen. He pledged about $577 million, and he has a $187 million guarantee. I think on Friday or Monday, his shares are going to be auctioned off.
When Leo says his shares, I want you to understand what that means, right? You have an asset, you gave the bank a mortgage, and you say to yourself, I can't lose this asset until the bank forecloses. And in New York, it might take them 3 or 4 or 5 years, other places a year and a half, etc. But guess what? They can sell the equity interest in 10 days. The Supreme Court of the United States has ruled that 15 days notice is more than
enough.
And if they sell that, and where do they sell it? Not on the courthouse steps, in their office.
Correct.
And they invite you to show up, and no one comes, and then you get a letter that we sold your equity interest. Now the lender or whoever bought it owns the entity that owns the building. The Jake are more.
I'm talking about the mental state of a gentleman like a Charles Cohen that literally pledged all of his yachts, his big buildings. He doesn't know the law. He's surrounded by these individuals that created those documents. They're not researching. They're in aghast. They're saying, what do we do? There's an alarm bell. There's emotional thinking. There's no temperament. So one of the first things you have to do is you have to slow the process down. And you have to give the information that we are trying to give to you today, little bits of information that may change your temperament in business decision making. When you're innovating office in distress, you are really taking stock of the market turmoil, the consequences of that, and how you traverse that. You do not traverse that with emotional pie thinking. You have to get competent counsel that understands how to traverse that terrain.
Thank you, guys.
Sure.
And here's my, where's your walking right here?